Thank you. Good morning, all. This case management conference is in the matter of CFI 091-2023 before His Excellency Justice Nasser al-Nasser. The claimants are represented by Altamini & Company. Lead counsel is Mr. Bobby Friedman. The defendant is represented by Emirates Legal, and lead counsel is Mr. Seb Oram. Thank you, Your Excellency.
Thank you. Mr. Friedman, you can start, please.
Thank you. Good morning, Your Excellency. As was just stated there, I appear on behalf of the claimants who are Access Group, DWC and ProX partners, and my learned friend Mr. Oram appears on behalf of the defendant, BLS International. Can I just start by way of housekeeping? Do you have the skeleton arguments from Mr. Oram and from me, and also do you have a copy of the bundle as well?
Yes, I do.
I'm grateful. And just by way of a correction that was brought to my attention in terms of the index to the bundle, the cover page has some of the wrong dates for some of the pleadings. I'm not sure it's particularly material, but just to note that the defence and counterclaim is dated the 15th of April and not the 18th of March of this year. The reply and defence to counterclaim is dated the 10th of June, not the 15th of April. And the reply to defence to counterclaim is in fact dated the 15th of July, not the 14th of July. So as I say, I'm not sure that will really matter very much for today.
It matters much.
Yeah, but I just didn't want you to be misled in some way. So, Your Excellency, this is, as you'll be aware, having seen the skeletons, the case management conference, and most of the directions are agreed. Really, there is one substantial issue between the parties, which is whether there should be an order for a trial of preliminary issues, or alternatively, my learned friend puts it as a split trial of liability and quantum. And I think it'd probably be helpful just to start off if I took you to the preliminary issues themselves as they've been drafted, and that's at page 100 of the bundle.
Okay. And
obviously I'll have various things to say about them, but you can see them there at the bottom of page 100. So trial of the following issues. A, whether the defendant validly terminated each of the subcontracts without the need for a court order because sums were outstanding from the claimant. If so, the effect of that termination on the enforceability of the non-compete clause of each subcontract. And C, the meaning of the non-compete clause of each subcontract. And then Manofra puts his fallback, or there's to be a trial of all issues of liability alone. So that's what we're arguing about today, just so Your Excellency has that.
Mm-hmm.
Now, we do say that this is a suggestion that has no grounding in sensible case management whatsoever. It's, in our submission, a nakedly tactical proposal and would be very unhelpful to the court, and in the end would be unhelpful to the parties. But it's ultimately, we say, been driven by a desire to try to keep us out of our money, because, of course, if this proposal were allowed, it would cause the most extraordinary delay. And in my submission, it's also not surprising that my learned friend in his skeleton argument doesn't mention any case law whatsoever, even though there is DIFC case law on this, as well as English case law referred to by the DIFC courts. And that's because from even a cursory glance at the case law, it is perfectly clear that my learned friend's suggestion just doesn't work and doesn't meet any of the tests, and indeed egregiously breaches all of the tests. So I'll make my submissions now in two parts. Firstly, I'll just deal with those principles that are not addressed, that are ignored by the defendant in making its proposal. And then secondly, I'll turn to the facts and apply those principles to the facts. And we say it does lead to only one conclusion. So if I could ask that we turn to page 124 of the bundle. And this is from my skeleton argument.
Okay.
And so this is just to navigate where we are in the skeleton argument. And I make reference there to the decision of Sir Jeremy Cook, who confirmed that the English approach to preliminary issues should apply. And that approach is set out in the well-known case of Steele and Steele, which was a decision of Mr. Justice Neuberger, as he then was, now Lord Neuberger, subsequently President of the Supreme Court. And I think it may help if we just very briefly go to the Nest Investments case, which is at page 206 of the bundle.
Yeah.
And in particular, I just pick up at paragraph 6. The parties were agreed that the criteria which failed to be applied are those set out by Neuberger Jersey, then was in Steele and Steele. And there are 10 questions which should be asked, and I'll take your excellency to those 10 questions in a moment. And then this is an important point to emphasize, the point made by Sir Jeremy Cook, is that it was common ground that there were any number of decisions where the English Court of Appeal had warned about the dangers of ordering such preliminary issues, and the siren song of the apparent shortcut, which turned out ultimately to be nothing of the kind. And now this is not a case actually where there is any siren song at all. It's not attractive to have preliminary issues. In other cases, it may appear superficially attractive. But the point that is made in those authorities and that's reiterated in Nest Investments is it's a kind of be careful what you wish for point, which is that at an early stage of case management, the court might think, well, actually, this might be a shortcut. This might make things a bit easier. But of course, as we all know, litigation is complicated. Things move on, things become more complicated, points arise. And so even if at this stage, and we say this is certainly no such case, but even if the court at this moment thought, well, actually, it might save us a bit of time, or it might save us a bit of money, that there is a very clear warning in the authorities that you absolutely need to exercise a huge amount of caution about any such superficial attractiveness, because it's been shown time and time again that is not borne out in practice. So if we could go back to my skeleton argument, and this is at page 124, so just to go back to where we were, and I've quoted in paragraph 18, again, for just one example, there are many examples of this, I'm sure they'll be well known to your excellency, but for example, in Tilling and Whiteman, where it was said in relation to a preliminary point of law, and of course we'll come to this in a moment, my learned friend isn't seeking determinations of points of law, he's seeking determination of hotly contested points of fact. But again, it was made clear there in the English authority that these are often treacherous shortcuts. Their price can be, as here, delay, anxiety, and expense. So then if we go over the page to page 125, we then turn to the factors in Steele and Steele. And I'll just run through these very briefly. And as I say, I'll apply them in due course. But the first one, most important one, is would this dispose of the case or one aspect of the case? Secondly, would it significantly cut down the cost and time involved in pre-trial preparation or in connection with the trial itself? Third point, if it's a question of law, and as I say, this isn't, but if it is a question of law, how much effort, if any, would be involved in identifying the relevant facts for the purpose of the preliminary issue? Point 4, if an issue of law, to what extent is it to be determined on agreed facts? Again, I'll come to it in more detail, but of course, this is one where there are essentially no agreed facts. On 5, we then have where the facts are not agreed, to what extent that impinges on the value of a preliminary issue, and I'll say greatly impinges on that value. 6, whether the determination of a preliminary issue might unreasonably fetter either or both parties, or indeed the court, in achieving a just result, and again that does so here. 7, to what extent there's a risk of the determination of the preliminary issue increasing costs and or delaying the trial, again a huge risk in this case. 8 is to what extent the determination of the preliminary issue may be irrelevant, and here it may well determine very little of value. 9, to what extent there's a risk that the determination of a preliminary issue could lead to an application for the pleadings being amended, so as to avoid the consequences of the determination. This is a case, although actually the preliminary issues decide so little that actually in this case there wouldn't really be need to amend the pleadings, because most points will be left open. And then point 10 is whether, taking into account everything else, it is just to order it. And then just to pick up on another case, the Court of Appeal decision in McLaughlin and Grovers, again, well-known English authority on this, the court there said that only issues which are decisive or potentially decisive should be identified. It is noted that, you know, sometimes if you could decide one point and that would effectively decide everything, but there's a very small amount left over and that would probably be settled, then, you know, it might in those circumstances be appropriate to, if all the other tests were met, to order a preliminary issue. But essentially you're looking at, are these decisive points? Then point 2 is reiterated, it should usually be questions of law, and those questions of law should be decided on the basis of a schedule of agreed or assumed facts. And you know, we all know the kinds of cases that would be involved, that might be involved in that sort of determination, where there's a clear legal issue, where you don't have to get into the facts. The parties agree that you'll assume that X is the case, and on the basis of X, how does the court decide this point of law? And again, this is very, very far removed from that. And then the fourth point is they should be triable without significant delay. And importantly, you have to make full allowance for the implications of a possible appeal. Because of course, this is again one of the problems with the shortcut, is that you have trial 1, you then, if you have other issues left over, you can't just go ahead and list trial 2. You have to have trial 1. You have to then allow for the full appeal process in relation to trial 1. Have to allow for that appeal to be brought, to be listed, to be heard, to be decided, to be potentially subject to any further appeal, of course, and only then do you get to trial 2. That is not a quick process. And then just to reiterate, I've given some further examples at paragraph 21 of the warnings that are given in the English White Book by reference to the cases. The point about that there's always a risk that a preliminary issue will lead to unnecessary expense and delay if it might not be decisive of the litigation. There's a particular warning about vagueness. You have to have crystal clear drafting of a preliminary issue. You can't have a preliminary issue where what it means, what it covers, is not absolutely crystal clear, because otherwise the parties won't be clear about what is in fact being determined when you have your first trial. So who knows what the witness statements are meant to address? Who knows what that first trial is meant to cover in terms of cross-examination and submissions? And then you get into all sorts of difficulties at the second trial, because one party is saying, well, if you wanted to raise that point, you needed to do it 2 years ago when we were having our first trial. And the other side says, no, that wasn't within the preliminary issue. So in general, not only do they have to be straightforward, simple, readily understood, but the drafting needs to be absolutely crystal clear, with no doubt, no room for any misunderstanding. And then the final point I make again from the White Book is there's a particular warning about calling witnesses twice. And it's obvious why that is highly, highly problematic. Because what do you do about cross-examination? What do you do about the credibility of a witness? If a witness is sort of asked about an issue in the first cross-examination, what do you do at the second trial? Are you allowed to ask them about that again? What if it's a sort of related issue? Can you ask the witness that again? What if the judge at the first trial has found the witness to be unreliable? Can you then rely on the witness at the second trial? Is it open to the judge at the second trial to find that witness to be reliable where the first judge has found that witness to be unreliable? All of those issues are incredibly complicated. And essentially, if you are having to get a witness back in the box, then it just doesn't work. the issues are so difficult that it cannot possibly be just to order that preliminary issue. And again, my beloved friend, I mean, this is an absolutely outrageous application for preliminary issues. It just falls foul of essentially every single requirement. It is a complete and utter try-on. And this again is another example. So with that introduction as to the principles in relation to this, I'll turn to the facts and maybe I've just shortcut some of this. I don't know how in what detail Your Excellency has read my skeleton argument, where I've set out the basis for this claim in some detail.
I have read your skeleton.
I'm grateful. So obviously, if points that I'm making don't make sense, you don't recall that as having been set out fully by me, please do let me know. But just for the purposes of time, I know we don't have a particularly long listing. I'll just sort of run through where we are on the facts, and obviously I can give Your Excellency references if that helps. But let's just take a step back and reiterate what the claims are. So my clients bring claims in relation to 5 separate contracts that were wrongly purportedly terminated on the 1st and the 11th of October 2023. So we have 4 of them that are referred to as the Spanish contracts and 1 which is the Cyprus contract. These contracts have similar but different terms. So, for example, in relation to the Iran contract, there is a different provision in relation to termination. There's no 6-month termination provision. They have different provisions in relation to the giving of notice. How you give notice is specific to each contract. They have specifics in relation to payment terms. So they are different in some ways. And we say that UAE law applies to all of them. Mr. Oram agrees in respect to 4 contracts, but in relation to the Cyprus contract says that English law applies. So that is not in fact agreed. But what we say is that there was no entitlement to terminate, and that in any event, to terminate, the defendants would have had to have obtained a court order. Now, this is all a matter of UAE law, and that if you had a court order, even then, we say, well, you had to comply with certain provisions as to notice, both in relation to how you do it, but also then the time period that lasts after that. Now, what we also say is that under UAE law, the defendants couldn't terminate unless they were acting in good faith and were not acting in abuse of rights. And that's a very important point, because we rely on a very substantial amount of factual material in relation to that. And that crosses over substantially with our case in relation to non-compete. So that brings me to the third point about our case, which is that we have the breaches of the non-compete clause. Now, my learned friend makes a very substantial error in his description of our case in his skeleton argument. He says that our non-compete case only arises after the purported termination of the contracts on the 1st and the 11th of October 2023. That is simply incorrect. We can see that in the particulars of claim at at page 12 of the bundle, paragraph 28.
Okay.
Now we can see that what we've pleaded our case is that by no later than the 29th of September, BLS was competing with our business. It actually goes back much further than that, because we can see at paragraph 27 that what we plead is that it was in the period from sometime in early 2023 up to around the end of September 2023. So we say, well, it's no later all of these things happened before the 29th of September 2023, but it actually started in early 2023. So our case, we claim for breaches of the non-compete clause throughout 2023. Now, because this is nefarious on the part of the defendants, as you expect, we don't have all of the documents. We need to get them on disclosure. But we know that it was happening from early 2023. And so we claim for breaches of the non-compete prior to the purported termination. So one of the key planks to my low friend's case on preliminary issue, bad as it is to say, well, the non-compete issue doesn't arise if he is right that that the non-compete doesn't apply after termination, because he says, well, it was terminated. But that's just a mistake. It's a mistake that he's made in relation to the pleadings. The non-compete case exists regardless of whether there was a valid termination in October 2023 or not. So that's a very important point that entirely undermines the premise of my low friend's position. And of course, we do, of course, claim for the non-compete post-termination. And it's a point that I've set out in my skeleton argument, which is that it's just to note that no reason whatsoever is given for why the non-compete clause would not apply post-termination. As I say, it doesn't really matter because we have a non-compete clause case prior to termination. But my learned friend in his pleading, we can see this at page 40. This is paragraph 49.5.
Yeah.
And he just merely asserts in the final subclause, the non-compete clause did not or will not survive that termination. Why? Doesn't say that. I mean, that's a pleading that's just a hopeful chuck it in. But you know, I don't need to persuade Your Excellency of this to say why we don't need a preliminary issue. But it's just to note that, you know, Mr. Oram says, well, there's no need to worry about non-compete post-termination, but he hasn't given any reason why. And that bare pleading wouldn't be enough. But as I say, the point doesn't really arise in the sense that we have a non-compete case prior to termination. Now, it's worth also going back to the particulars of claim, if I may, at paragraph 39, which starts at page 16 of the bundle.
Yeah.
And this deals with some of the points in relation to their case on breach, in particular breach for non-payment. And it's worth just bearing in mind how many limbs there are to our case in opposition to this. So we start off by saying that firstly, they needed to have been acting in good faith and not in abuse of rights. And again, just to make the obvious point, that we have a very extensive factual case on that. And we say, but even if they were acting in good faith and not in abuse of rights, and even if they had applied to the court, because we say they had to have applied to the court, we then say, well, if they're right about both of those, you would then, in the case of 3 of the Spanish contracts and the Cyprus contract, it would need to still be 6 months of notice from when it went to court. For the Iran Spanish contract, you wouldn't have that entitlement at all. And we then have all our further points going from 39.1 onwards. We have our entitlement to suspend the making of payments due to the breaches of the non-compete clause, which was ongoing. And my learned friend, I have to say, makes a really awful point in his defence, where he says, well, they haven't said that they did exercise that right. But obviously, we're saying that we were, in fact, entitled to suspend the making of payments. and that is a complete answer to that. But be that as it may, that's a point for trial. We then make a factual point that any breach would have been cured prior to the relevant time, which was some time which was in the future. We also make the point that it wasn't a material breach, but even if it was a curable breach. We therefore say that they needed to provide, there therefore needed to be a valid written notice, and 60 days had to pass. We make the point that there is no, as a matter of fact, no purported notice was given at all in relation to 4 of the 5 contracts. In relation to the one contract where purported notice was given, we raise a whole host of points about why it didn't count as valid notice. It was addressed wrongly, but both to the wrong entity, to the wrong place, to the wrong address, was sent by the wrong method. There was overcharging in the invoice. There was punitive interest, which was not allowed to be applied. In any event, we say that even if they were right about everything else, termination couldn't have happened until the middle of November, not early October. As I say, we also at C, we can say we would have paid all of the sums. We then make the point that there was an agreement or a waiver in relation to a 30-day payment basis. If we're right about that, then on any view, they couldn't terminate at the times that they said they could have terminated. We say there was no valid invoice served. And we say in any event, there was no material breach. So I accept that's a lot to take on board, but those are all of the hurdles that my learned friend would need to get through going to just his first preliminary issue. Shows it just obvious that it's not suitable to be a preliminary issue. Then if we just go briefly to the defence at page 39 of the bundle, this is just to pick up on another point on the non-compete clause.
Which paragraph?
This is paragraph 49 at the bottom of the page.
Okay.
So what my learned friend pleads in his defence is that it's denied that there's a breach of the non-compete clause, or otherwise acted in breach of contract. What he says is the business of the defendant, in fact, was that of an external service provider. So he makes a factual case about what his business was. So that case as to what the business extended to is a matter of fact that would need to be determined. And then we see at paragraph 49.2 that consequently, as a result of his fact case in paragraph 49.1, he denies that we have in our pleading correctly identified the nature of their business. So the first point is there's a dispute about what the nature of the business is. And it's also worth going back, if I may, to paragraph 48, which is about the facts as to what they did. So this is a separate point on the non-compete, where at paragraph 48.1, there is some limited admissions in relation to the actions that they took. But it's then apparent at 48.2 that they deny substantial parts of our fact case. And they don't address significant aspects of our case on the non-compete, which they sort of seek to bypass by not dealing with them specifically. So not only the question as to what my learned friend's business is a matter of fact, but what actions they took in relation to the non-compete is a matter of fact and not agreed. If we then go to page 41 of the bundle, and to paragraph 52, this is just to show, and I'm sure Your Excellency will have this, that they do plead a large number of breaches against us. So we can see on that page 41, misuse of the visa application appointment system. Over the page, conflicts of interest, misreporting of service fees. Page 43, we have non-payment of sums, breaches of data protection, and it goes on. And if we go to paragraph 55, which is on page 45,
yeah.
What we can see here is that where it's suggested that there were monies due, this is just an illustration of one point that does need to be determined amongst many others. My learned friend relies there on a number of invoices where on any view, by the time of the purported termination of the contract, the 60-day period had not expired. So he relies on invoices on the 15th of September in relation to a purported termination 2 weeks later. So that's just an illustration of one of the many fact issues that will need to be determined. And we can see over the page at paragraph 57, in relation to the Cyprus contract, they claim they can terminate for breach in relation to a sum of €540. Now, there are all sorts of reasons why we oppose it, but it's just, again, to give one example, the kind of issues we have to get into. Then at paragraph 57.2, another example of what he says. He says, if the letters of the 1st and the 11th of October didn't dissolve the contracts as a result of a breach, they gave notice to bring the new Spanish contracts to an end. None of them had a fixed term, and so he was entitled to terminate. So saying, well, I have this fallback case. But this only illustrates the point that actually, even if, I mean, this is his case if he says, well, if they don't terminate at all. But even if his letters of the 1st and the 11th of October did terminate, well, you then have to say, but on what terms? On what date? Was it 60 days thereafter? Was it 6 months thereafter? Was it some other date that the court would order? All of these are questions that would need to be determined in due course. So those are some of the complexities. And then we go to my learned friend's counterclaim. And we see this from, if we see this at page 51, we can see this at paragraph 71.
Okay.
And he claims for various sums that he says are owing, coming to just under 500,000 euros. We then have at paragraph 74 a claim for an account, and he bases it on a contractual duty. Over the page, effectively brings a claim that's sort of similar to a common law duty to account due to inaccuracies in the accounts. And we then have a further reason based on undercomputed profit share. We then have, over the page again, he seeks an order for contractual termination. So saying, well, if he hasn't terminated, he's going to try and terminate again. But then he claims in any event an indemnity and damages for loss of reputation. So all of that will need to be determined on his case. So that's where we get to on the pleadings. Now, if I could ask Your Excellency to go back to my skeleton page, if we pick this up at page 128.
Yeah.
So this goes to the first fatal reason, which by itself just knocks out the idea of these preliminary issues, because none of this would remotely be determinative. Doesn't matter which way it's decided. Now, let's say my clients succeed. Now, of course, very significant issues will still remain. My learned friend says that he's entitled to terminate the contract for a whole host of other reasons than those that are the subject of the preliminary issues. We would still need to make good our case on causation and on loss and so on. Our claim for the non-compete clause would be extant, wouldn't have been determined. All of that would need to be determined as well, on top of the claim for breach arising from purported termination. And I think it's probably fair to say that my learned friend would still have parts of his counterclaim. So you'd have to have another very substantial trial on any view. Now, what about if my learned friend succeeded on all of the issues? As I say, he got this wrong. They misunderstood our case. We would still have claims for breaches of the non-compete clause prior to any alleged termination. Now, that would all be based on the factual cases to actions taken by BLS. The same factual points would have been investigated during the first trial. Now, even if he were right on all of the preliminary issues, it doesn't answer the question as to when valid termination took place. Even if those letters in early October did validly terminate, the question is, well, with what effect? Was it on 6 months' notice? So that would remain. We then we still have questions as to, well, was valid notice given at all? Were the notice provisions adhered to? What about the fact that we had an agreement that there was a 30-day payment period? What about the terms in which purported notice was given? Now, if my learned friend had succeeded on everything, he'd still have all of his other counterclaims. All of them would need to be determined. His claims for damages for loss of reputation, his indemnity, all his other heads of loss. All of those breaches that I showed you that he's got in his pleading, all of those wouldn't have been determined. So they would have to be determined as well. And as I say, the reality is that we know that the question of the non-compete post-termination would also remain, because his only argument on that is a bare assertion in a subclause of his pleading, which doesn't stand up to any scrutiny. So I do say that the lack of decisiveness, which is set out as the decisive factor, key factor in McLaughlin and Grover's, just can't be, he cannot possibly suggest that is met. Now, the second key reason is the extent of the factual inquiry that would be required. And again, my learned friend's position on this is pretty desperate. In his skeleton argument, he says that there could be an attempt made to have an agreed schedule of facts. Well, I'm sorry, that doesn't work at all. If the schedule of facts are agreed, then they have to agree our facts. If he's trying to get judgment on a preliminary issue, and on our facts, they unquestionably would lose. But the point is, this is a fact-heavy set of issues, and it couldn't possibly work. Now, they have identified in their case management information sheet 9 witnesses. Now, we don't think they need 9 witnesses at all at trial. We'll correspond with them about that in due course, but let's say they do need them. Now, in the brief time I've had to take instructions on that, we actually only know who 7 of the 9 are at this stage from the short time I've had to make these inquiries. All 7 who we know, if they are called, we would need to cross-examine them on the preliminary issues. They would all go to matters relevant to the preliminary issues, so we'd have at least 7 of their witnesses that would need to be called. And given that all 7 who we know would be called, then it probably would have to be all 9. Now, all of those witnesses would need to be called second time around. So again, that just breaches one of the absolute red lines, which is you don't call witnesses twice. But again, that's my learned friend's proposal. And I've set out at paragraph 24 of my skeleton argument, page 127 of the bundle, 12 factual issues on which you'd need evidence if these preliminary issues were going to be decided. And so that really should, again, that one factor alone should be the end of the matter. Now, a third and again decisive reason is because of delay. The parties are agreed, it is common ground, that if you reject Malone Friends' application and we have one trial, that will take place at the same time as the preliminary issues trial in June of next year. So in 10 months' time, we'll be done. Compare that to what we will end up with in the alternative. We'll have to have two trials. I've already shown Your Excellency that. So the first trial will take place at the same time. So at some point, let's say we get a judgment in a couple of months. So we would know the full answer, if I'm right, in August of 2025, say around then. If my little friend's right, we get that in August 2025. He has to put in the documents on the appeal. The appeal might take place, say in about a year, something like that. We don't know. You have, again, I took Your Excellency the guidance. You have to allow for the appeal first before the second trial. So that takes us to the middle of 2026 at a rough guess. And we would then have to go through the pre-trial process all over again. My little friend says you'd need new witness statements, you'd need new expert reports, you'd need a new pre-trial review, and you'd need a new trial. So inevitably, that leads us to a trial in mid-2027 plus judgment. So you're taking a process that from start to finish, we would expect to have judgment in no more than a year from today, possibly less, possibly 10 months. So you have 10 months to a year, and that's taken up to about 3 years. That cannot possibly be right. You then have the time required, and on any view, this trial is going to be, the preliminary issue trial will be very substantial. My learned friend says, well, maybe 2 or 3 days. That's, in my submission, not realistic. As I've said, we're going to have to call, we're going to cross-examine at least 7 of their witnesses, and we'll have substantial submissions on UAE law, potentially on English law, potentially on Spanish law. But, regardless, it's not going to be much less than, say, 5 days. We might save a bit of time compared to the full trial, because like I said, some of the facts, a small amount of the facts we might not have to deal with, but we're easily looking at 5 days. And the parties are agreed that it's about 6 days for the whole trial if it's dealt with in one go. We say 6. My learned friend says 6 to 9, and with the suggestion that the court will be told later on if those additional days can be dropped. But either way, you're looking at a very substantial trial in June of this year, and again another very substantial trial thereafter, because you'd have to get all the same witnesses back, you'd have to deal with experts and so on at the second trial. So you probably go from one trial of about 6 days to one trial of about 5 days and a second trial of probably about 5 days. And of course, the cost will all be much, much greater because Malone accepts that you'd have to have 2 rounds of witness statements. He accepts that there'd have to be 2 pre-trial reviews and 2 trials. And so that makes it much more complicated. He says, well, he proposes dealing with all the disclosure in one go. But the reality of a case like this is that, you would have more requests for disclosure after witness statements, when witness statements bring up new issues, and the parties inevitably will write to the other side and say, well, you've raised this. What about disclosure on this point? So we'll end up with a disclosure process going on potentially for years. Now, just picking up on some of the points Malone makes in his skeleton argument, he says that one of the reasons why his first trial would be shorter is because you don't need to address the non-compete question, the facts on the non-compete. But that's wrong, because and this is for your note, Your Excellency. You can see this at paragraphs 37.1 and 37.2 of the particulars of claim. We rely on essentially the same facts in relation to non-compete as to the facts in relation to bad faith and abuse of rights. And in order to determine whether there was valid termination by the 1st of October letter, you need to determine the question of abuse of rights and good faith. So all of those questions will arise, come what may, at the first trial, but my learned friend is right, they will arise at the second trial as well. And as we say at paragraph 37.2, point that I've already made, is that we say that they have been acting in breach of the non-compete clause for many months, allowing us to suspend any obligation to pay. So his preliminary issue is based on them having a right to demand the monies from us. But we say, because they were in breach of the non-compete clause, they did not have the right to demand those monies from us. So there couldn't be a squarer overlap. And again, I do have to say, the whole premise, as my learned friend put it in the skeleton argument, is based on a misunderstanding of the case. The other point my learned friend makes at paragraph 13 of his skeleton argument is that he complains about the prolixity of our legal arguments in relation to the contractual right to terminate. And he refers to issues 22 to 30 of the case memorandum. I don't think we need to go there, but for your note, that's at page 88 of the bundle. But again, the point is that those points will have to be determined on the preliminary issues trial. So it's not going to make things any easier, and they'll be relevant as well on the second trial. His next point, at paragraph 15 of his skeleton argument, is that he says we can't have a claim for damages if termination was legally valid. And again, he's just wrong about that. There are two reasons. One I've dealt with at some length already, which is that we have damages for the prior breach of the non-compete. But the second one is because of this notice period point. Even if he was entitled to terminate on the 1st of October, and remember, we have all sorts of fallback cases that even if he did have some entitlement to terminate, it would have actually been in November and so on, or 6 months or 60 days later and so on. But even if he was right that it was on the 1st of October, he had a right to terminate, we say that that wouldn't have been an immediate right to terminate, and he'd have had to, in the case of a number of the contracts, given 6 months notice. And we were entitled to damages because they didn't, even on his case, he didn't correctly exercise that right to terminate because he sought to do it immediately. So again, that's another answer to that. And then paragraph 16 of his skeleton, he says, well, if they win on their preliminary issues, that would reduce the scope of the good faith abuse of rights points at the second trial. Well, as I've already dealt with, we would have to deal with all of the points on good faith and abuse of rights at the first trial because they go to my learned friend's entitlement to payment, and they overlap also in large part with the breach of the non-compete. But in any event, he doesn't give any reason why that scope would be reduced at the second trial. So just to then pick up on some final reasons why it wouldn't be right to make this order, it would duplicate the pre-trial steps. As I've said, you'd need 2 PTRs, 2 sets of witness statements, and it would fetter a just result. What the fettering a just result pointed about is that, does the court end up making a decision at the first trial, and then the court gets to the second trial and say, oh, I wish I'd known that, well, you know, something's come up, a point has come up, and it might have been relevant to the first trial. So, you know, to give an example, their motive, BLS's motive, is highly relevant to the preliminary issues, good faith, abuse of rights, and so on. Now, could the court be confident that something might not come up on cross-examination in relation to one of the witnesses that would shed light on what they were thinking, what they were doing, something on their credibility, whether they were telling the truth at the second trial? That's exactly the kind of thing that might come up later, and that would mean that that first result wasn't just, and the court wants to know everything. Now, the final point is just about the lack of clarity. As I took Your Excellency to, these issues need to be drafted perfectly. They need to be crystal clear. There can be no doubt about what they mean. If we go back to page 100 of the bundle, and this is what has been drafted. Now, at A, we have whether the defendant validly terminated each of the subcontracts without the need for a court order because sums are outstanding from the claimant. Now, the first point is that subcontracts aren't defined, so that's a meaningless term. Again, precision matters. What are we talking about by subcontracts? We have the Spanish ministry contract, we have the Spanish contract with BLS, we have the further contracts that are said to have existed between Spain and BLS, and then there's the contract with Cyprus, and then there are all sorts of other contracts and extensions, so we don't even know what that is about. We then have this discussion about validly terminated, about because sums were outstanding, but what sums, in relation to what contracts, at what time, on what dates? When it said termination, that there was a valid termination, at what date is that? Is that at the 1st of October, the 11th of October, sometime in November, 60 days after the 1st of October, 60 days after the 11th of October, 6 months thereafter? What does it mean? And if terminated, well, when? Is that included in the preliminary issue? With what effect? What's the effect of that termination? Is that within the preliminary issue? We don't know. It's just not drafted in anywhere near the form that you would need to do. You'd need to rip it up and start again. Point B, well, my learned friend accepts very fairly at paragraph 18 of his skeleton that issue 2 depends on issue 1. So that's no better. But issue 2, which is at 1B, is also unclear. If so, the effect of the termination on the enforceability of the non-compete clause, that's an entirely nebulous term. What on earth does that mean? It is not a clear and defined issue. And the third point, the meaning of the non-compete clause of each subcontract. Well, the meaning in what sense? What is included in that? What isn't? What are the points that the court is actually meant to decide? And again, none of that is spelled out, and that's just a basic failing. And I do have to say, in my submission, this is a thoroughly misconceived suggestion from start to finish in relation to preliminary issues. Now, my learned friend has this fallback in relation to quantum, and the position is not much better there either. Most of the same points apply. Firstly, there would be the same very substantial delay. Again, it's accepted by my learned friend that quantum could be dealt with at the trial in June, so we get our answer very shortly. But if you kick it off, look, this is why they want to do it, because they know they're going to have to write us a check, trying to put off the day when they have to do it. You then have to allow for the appeal. You then have to allow for new witness statements. You have to allow for expert reports. You have to allow for a second trial. So again, you go from quick decision in 2025 to long grass into into most likely 2027. So again, that is pretty egregious. Secondly, it's obviously more convenient to deal with all the matters in one go. And again, that means that any appeal can take account of all of the issues. Again, you'd have the same additional expense. You'd have legal representation at 2 trials. You'd have 2 pre-trial processes. You'd obviously waste court time. And you would inevitably end up with 2 disclosure processes, because obviously disclosure goes to the expert issues. That's common ground. You can see it from my learned friend's case management information sheet, where he refers to all sorts of disclosure requests that relate to quantum. So otherwise, because he says deal with it all in one go, but the point is the expert will come in and doubtless will say, well, I think I'm missing this. Could you ask for this? And so you'll end up with 2 disclosure processes. You obviously will need quantum either way, because we, on our case, if we succeed, will require quantum evidence, and my learned friend's counterclaim raises quantum evidence. And then fifthly, a really important point, having a better idea of quantum will make settlement much more likely, because this is a case where on any view, the calculation of quantum has some complication to it. And so both parties, by having their expert report going into the trial, will know the parameters of what's in dispute money-wise. If we don't have that, imagine trying to mediate this before the trial. There'll be arguments about liability, but you then have an argument about quantum without any expert evidence, and so you're sort of discussing it in a vacuum. So I said that's a very substantial reason why we need it all dealt with it in one go. Now, what do they say on this? Well, not a lot. The only point my learned friend makes is to say, well, our quantum case is not properly pleaded. It's a pretty odd complaint to be making now, I have to say. My learned friend had our particulars of claim since the 26th of February. That's more than 6 months ago. They could have at any point put in a request for further information if they needed more, but they didn't do so. And they can't have expected us to do it in our reply, because obviously quantum is our primary case. That's a matter for our particulars of claim. But in any event, our reply was 2.5 months ago now. So if they did have a problem, the RFI could have been made 2.5 months ago, and they should have queried the position. And I do say, regardless, that the complaint about quantum just is ill-founded. If we go to page 18 of the bundle.
Yeah.
And this is our case on this. And we set it out very clearly that they wrongly terminated the contracts, and our loss is a sum of money that we would have received but for the purported early termination. It's the ability to carry on our business versus the position now. That's very clear. That's the primary claim. We then have the claim in relation to the non-compete. And again, we make this clear, which is we say it's the same point. It's the difference between what we earned, what we would have earned and what we will earn based on the period up to the end of the non-compete. And then we say we have an alternative case, which is effectively a release fee case. And then we have at paragraph 43, a fallback, which is effectively claiming costs from our disorderly dissolution from the way in which they terminated. And then at paragraph 44, we do provide an indicative figure. So we say our net profit was $2 million a year, and effectively our business has been destroyed. So they know the years. We've particularized how long the contracts would have lasted for. That's all up in the pleading. And we've said it's at least $2 million a year. So they've got the figure and they know the number of years. So in my submission, that pleading is perfectly clear. The reason why you need quantum evidence is that obviously carrying out the very specific calculation, looking at future lost profits, is something you need an expert for. And it's unrealistic to suggest that we would have done it without our expert. But we've got a fully pleaded claim in respect of loss. But in any event, as I say, they've had 6 months to query it. They haven't. Even if they're right to query it, they've put in their case management information sheet that they intend to serve us with a request for further information. Well, the answer is they can make their request for further information and then it can be answered as appropriate. And so the idea that somehow there's a problem with our case on quantum is just manufactured immediately prior to this CMC at around the same time that they've come up with their aim of having these preliminary issues. But in any event, even if they were right about all this, it wouldn't justify their preliminary issues, and it wouldn't justify a split of liability and quantum, because either way, matters would be made clear. Either way, you would have the experts before trial. And so if there is a problem with our case on quantum, everybody's agreed it could be dealt with by the time of the trial. So the point is it can be resolved and dealt with at the trial. So that is simply not a reason to split the trial. And as I say, and just by way of a final point, we see this from their case management information sheet. This is at page 95. At the bottom of the page, we can see the numbers. The sorts of things they're asking for in disclosure are the end of year and management accounts, the financial forecasts and projections. And they're seeking this financial information for their quantum case. So what is envisaged between the two parties, and as is reflected in the directions which otherwise would be agreed, is that you have disclosure, including in relation to matters of quantum. You then have the experts setting out the very specific case, giving their expert evidence in relation to quantum, and then it's all dealt with at the trial. And so there's nothing surprising, unusual, or difficult about that. So in my submission, there's no basis whatsoever for the preliminary issue or split trial. As I say, there are clear principles that apply in relation to this. This proposal does not meet those principles, and in my submission, the court should reject the defendant's proposal.
Thank you, Mr. Friedman.
Thank you.
Mr. Oram.
Morning, Your Excellency.
Hi.
What my learned friend submissions have ably demonstrated is that if this goes to a full-length trial, the number of points that are an issue are going to turn this into a very long and expensive trial. What we're trying to do on the defendant's side is identify whether there is a way through proper case management of reducing those issues and identifying what is centrally in dispute between the parties in a way that will, if not determine the dispute, will significantly reduce them for a trial on quantum. Your Excellency, I will go through probably a little bit more slowly the issues on the pleadings that are relevant to those preliminary issues. Where I don't disagree with my learned friend is in principle with the law that applies to preliminary issues. Where I do heavily disagree with him is his analysis of why this case is appropriate for preliminary issues. And the key division between us is what those issues would involve and what on the pleadings is in issue and would need to be determined in order for those preliminary issues to be decided. So what I propose to do is, one, explain why we're here, two, then go through parts of the pleadings that are relevant to preliminary issues in order to identify, one, what the trial judge would need to determine, two, what would be left for a subsequent trial. One perhaps significant dispute between me and my learned friend on the law is whether or not it is preclusive to a preliminary issue, in other words, whether or not the court should order it, if there is some residue of a case that's left to be determined later. And on my submission, the fact that there is something left for a quantum trial is not preclusive of a preliminary issue being ordered if the result of the preliminary issue is that that becomes more confined and easily managed by the trial judge. Turning then to why we're here, in other words, what it is that the court is being invited to case manage this morning, my client's case is pretty straightforward. October 2023 is the key termination date. Between June and October 2023, my client had received no payment from the claimants under any of the 5 contracts to which this claim relates. So we terminated because we weren't being paid money and a substantial debt had accrued. What is generated in the pleadings subsequent to that is a far broader dispute. It is about what was going on in the background at the time of termination. It is about whether or not we were competing unlawfully and in breach of a contract. And it is about the financial claims that each side has against the other. So my learned friend's client says, I'm entitled to damages for wrongful termination and or for competition. My client says we're entitled to substantial sums that were due as a result of the accounting mechanism under the contracts. The first case management issue, and the key reason why we're asking for this, either preliminary issues or a trial that is split between, on the one hand, liability with quantum to follow, is the way in which the case on loss is being put by the claimants. And essentially, that is sufficiently unclear at the moment that the proposed directions that the claimants are suggesting to be wholly unjust for my client to go to trial on them. May I start with the case management bundle at page 18? My learned friend touched on them briefly. And I'm looking at paragraph 41, which starts the section causation, loss and damage in my learned friend's pleading. That tells us that there are 3 kinds of loss that are being claimed. In paragraph 41, there's a claim for lost profits that would have been earned, but for the wrongful early purported termination of the contracts in question. So lost profits for the period that contracts would have been performed. That's repeated at 42.1 in relation to the allegation of wrongful competition. The 42 says BLS would have continued to work with the claimants such that the claimants have lost profits covering the same period in time as covered by the non-compete clause. The second head of damage, 42.2, is a sum of money in order to release the defendant of its non-compete obligation. The third head of damage is at paragraph 43, which is loss and damage to the claimants due to the immediate negative impact on their business of purported termination, which caused the claimants to lose staff and other infrastructure and to incur costs. So in some way, losses associated with an early termination is the third head of loss. There are no particulars that are given of any of those. All that we get at paragraph 44 is that the precise amount of those losses in each case will be the subject of expert evidence and will be particularized in due course. And 2, by way of indication, the lost profit, the relevant net profit was in the region of $2 million per year. It is expected that the claimants will suffer at least that amount for the loss of each year claimed. Now, the relevant years over which those losses are claimed start at the point of termination, apart from the non-compete clause, and go on for the period that the contracts were said to have had a fixed term. Now, the reasons that doesn't matter, but it goes up until March 2028. So it's a period of around 4.5 years. Yeah, 4.5 years at $2 million per year. These brief 5 paragraphs are apparently setting forward a claim in the region of $9 million. The proposal that you're being asked to put by the claimants to direct is that there is a trial of all issues of liability and damage, including these 5 brief paragraphs, in circumstances where we don't know what their case is, we don't have the proper basis on which to instruct experts to say, this is what you're being asked to look at in order to calculate those losses. And in those circumstances, it would be grossly unjust for that to occur, and we're looking at a different way to case manage the proceedings. At page 49 of the bundle is part of our defence and counterclaim. And at paragraph 65 of that, we properly raised the complaint that paragraph 44 is improperly pleaded because it doesn't set out the relevant facts. So immediately as part of our case in response, we drew attention to that complaint. The reply came in, that's at page 74 of the bundle. And the relevant paragraphs are 65 to 66. The short point is they completely ignore that complaint. So there's no reference at all to the complaint about the way in which damage is being put. The directions that you're being invited to make don't in any way cure that. So the directions at page 100 of the bundle there is nothing in those that would allow the particularization of the claimant's case on loss and damage. What it would do instead, at page 101, is there would be document production in late this year, third and fourth quarters of this year. Witness statements will then be directed in early next year, at paragraphs 11 to 13. And the only point at which we would find out about the claimant's case is from paragraphs 14 down to 18, which deal with experts. And so the proposal the claimants are suggesting is that both parties at the same time serve their experts' reports on the 7th of March. So we're expected to respond to a case at the very same time that we hear about it. And then there'd be a period for joint memoranda and reply expert reports. Turning then, for the moment, just to get an idea of what the case is about and what the trial judge would have to determine, what adds complexity to this case, and I'm going now to the memorandum that has been produced between the parties. That's at page 86 of the bundle. The issues that give rise to the complexity are, I would suggest, 4. The first is the entitlement to terminate. That's issues 22 and 23. The defendant relies on 4 or 5 heads on which it was entitled to terminate that give rise to a number of factual disputes. I'll go through them in a moment, but just to identify for the moment that that's the principal dispute area number 1. The second is the effect of termination or the permissibility of termination under the law of the United Arab Emirates. That's issues 24 through to 30. The third area of complication is issues 26, issue 38, which is there a breach of the non-compete clause? That gives rise to a factual examination of what was happening in the 4 months before termination in order to determine whether we were doing anything wrong. And the fourth issue that gives rise to complexity is each side's financial claims. I've gone through the claimant's claim in some detail to explain how that's currently set out and how it's proposed that those would be determined and clarified going up to trial. There's then our side of the damages point, which is establishing the amounts that are due to my client and the accounting for debts. That's the case in outline. I'm going to now just address briefly the law that my learned apprentice has taken you to, and then how I say it applies in relation to the case management decisions that now arise. In relation to the law, there is very little between us. The points on which I rely starting at Nest Investments at page 204 of the bundle. In my submission, the first key paragraph is paragraph 19 in the judgment of Mr. Justice Jeremy Cook. That's the test that he applied. The real nub of this, sorry, this is at page 208 of the bundle.
Yeah.
The real nub of this appeal turns on the application of the criteria in steel, which this court must apply for itself. I bear in mind the particular warnings given by many courts, including the English Court of Appeal and House of Lords, about the dangers of ordering preliminary issues which beguilingly appear to represent a shortcut, but when facts are established, turn out to prolong the case and increase the expense. I need not set out the overriding objective in RDC 1.6 of dealing with a case justly, or RDC 26.35, which requires the court to consider at a CMC whether it will be just and will save costs to order a split trial or the trial of one or more preliminary issues, but note that these are relevant matters in the decision I have to take. So His Lordship considers those rules of the RDC, ultimately, is it just and will it save costs, having regard to the overriding objective, and relevant factors are those in paragraph 6 of the judgment, which my learned friend has already referred to. And there, Mr. Justice Jeremy Cook says, 1, 2, 3, 4, 5 lines down, the exercise in the end is one of cost-benefit analysis in determining whether or not the ordering of preliminary issues is likely to lead to savings of time and costs in the efficient administration of justice. So that, in my submission, is the key issue that guides this decision of whether or not preliminary issues should be ordered in this case. That is reinforced in my submission by Steele and Steele, which is the decision that Mr. Justice Jeremy Cook applied. That starts at page 197 of the bundle. The passage on which I rely starts at page 200 of the bundle. The third substantive paragraph from the bottom of the case starts, having heard arguments and considered the matters, I have reached the conclusion that it would not be appropriate to determine this preliminary issue. What His Lordship then does is consider the factors that one takes into account. My learned friend has gone through them, and I won't repeat them. But at the end of that analysis, point 10 is at page 202 of the bundle. Fourth paragraph from the end, Mr. Justice Neuberger says, tenthly, the court should ask itself whether, taking into account all the previous points, it is just to order a preliminary issue. In this connection, it should be mentioned that the 9 specific tests overlap to some extent. So it's ultimate question of justice, the same as in Nest developments. And may I draw Your Excellency's attention to the second last paragraph of that judgment at page 203, which says this: preliminary issues have received widely varying judicial comments through the years. In Tilling and Whiteman, Lord Scarman described preliminary issues as often being treacherous shortcuts, which can lead to delay, anxiety, and expense. On the other hand, it is clear that the determination of preliminary issues can be very beneficial, as that's a relevant provision for immediate judgments under the English court rules recognises. To my mind, as is so often the case, there are inevitably conflicting factors. The determination of a preliminary issue can be a very satisfactory way of cheaply and quickly disposing of the case or part of the case. However, as this case in Tilling and Whiteman show, careful thought should be given to the possible consequences, benefits, and disadvantages of having a preliminary issue before that course is deployed. Your Excellency, I entirely accept that careful thought needs to be given to the way in which the preliminary issues are framed.
Can I just ask His Excellency read the following sentence just while he's there, just so I don't have to go back to it. Sorry, I didn't mean to interrupt, but I just thought it would save a bit of time.
Thank you.
What I do pick up on from this paragraph is that it may be appropriate to order preliminary issues if it is a way of disposing of, and I quote, the case or part of a case. I turn then to the preliminary issues that we're asking this court to direct and why they're appropriate in light of that guidance. Issue 1 deals with whether or not we were entitled to terminate for one of the reasons that we've identified. And it was the key reason that we were identifying contemporaneously, which was that we weren't being paid for a number of months. I just want to track through the pleading. What is an issue in relation to that preliminary issue? One starts with the relevant clause, was at page 31 of the bundle. 26.6, we have pleaded the term and termination provision that governs all of the Spanish subcontracts. And I've separated out the relevant clauses. So the first one deals with the expiry date, so a fixed date of expiry, with which this ground of termination is not currently concerned. It's the second paragraph. Either party may terminate this agreement immediately by written notice to the other party in the event of a material breach by the other party if the breach is not curable. Whereas if the breach is curable, then the termination shall have effect upon the expiry of 60 days from the notice intimating a material breach if it is not cured within the said period of 60 days. So that's the provision which we say is engaged because of the non-payments for a number of months before October the 1st and October 11th, 2023. That is replicated in the particulars of claim, and there's no dispute between us that it applies to each of the relevant subcontracts. So, page 7 of the bundle, paragraph 12, the claimant pleads the same thing in respect of clause 7 of the Ghana and the Kingdom of Saudi Arabia contracts. And then at the end of that paragraph, says that the Iran contract is a materially similar terms to the termination clause. So Ghana, KSA, Lebanon, and Iran contracts all had this relevant provision. There's then an assertion going through to paragraph 22.2, in which termination occurs. And the claimant pleads the letter of the 1st of October 2023 sent by the defendant, which wrongly purported to give notice of termination of the Spanish contracts. So the fact of the letter is not only admitted but relied upon by the claimant. It's whether or not it was wrongful that is an issue. And at paragraph 32, the page 15, claimant sets out its case as to why the termination was wrongful. For that, it starts at paragraph 32. For the reasons set out above, and by no later than around May 2023, BLS had determined that it would purport to terminate the Spanish and Cyprus contracts, regardless of its contractual right to do so. So this starts the following paragraph, in which the claimant is saying, you terminated not caring whether you had a right to do so under the contracts. The issue is whether we did have such a right. It then pleads the 1st of October letter at paragraph 33. It pleads at paragraph 34 the basis on which the defendant was relying, i.e. certain invoices were outstanding for payment, and sets those out at paragraph 35. The key paragraph in my submission is 35.2, in which the claimant says why it was wrongful nonetheless to terminate. A response by Access Group, which raised the fact that Access Group suspected that BLS was in breach of a non-compete clause and requested undertakings in relation to the non-compete clause, and B, rejected the assertion that 1.35 million reals was due. In fact, as explained in that letter, Access Group has been overcharged by 166,000. So the allegation that's being made in this part of the particulars of claim is not that nothing was due, but there had been an overcharge of 166,000 on an invoice of 1.35 million. One then turns to the defence and counterclaim, And first at page 41 of the bundle. Section C2 of that sets out the alleged wrongful termination and the response to that. At 52, we set out a relatively long paragraph that sets out all of the reasons for which we were entitled to terminate. So there is first misuse of the visa application appointment system, then conflict of interest between staff and commercial agencies, then misreporting of service fees collected from visa applicants and agents. 52.11, one of these grounds is non-payment of the sums due under the Spanish contracts. And then it finishes with the breach of the data protection, security and confidentiality provisions. So there are, if it's to go to a full trial, a number of grounds which require factual exploration, witness statements and so on, in order to deal with all of those grounds. But one of those is about the invoicing and the debts that we were claiming between June and October 2023. The pleading goes on to set out those amounts at 53, and at 56, we summarise our case in relation to why we were entitled to terminate. We say by the 1st of October, Access or the claimants, one, had ceased making payments under each of the new Spanish contracts and had not accounted for any services supplied since June 2023. Two, had repeatedly ignored demands to make payments under the terms of the contracts. And three, had rejected the default notice served under the new KSA contract. By that conduct, they evinced an intention not to perform the contracts and not to cure the breach consisting of persistent delayed payments. And then at paragraph 60, we assert that we terminated the contracts lawfully in good faith for each of the reasons in paragraphs 52 to 56. So in other words, any one of those termination grounds would have been sufficient, but we rely on all of them in order to justify the termination. So the first question in relation to issue one of the preliminary issues is what exactly is the court being asked to determine, and what would it need to determine in order to decide that issue? Issue one deals with whether or not the termination ground relation to the outstanding payments was a good one, and if so, if that gave us the right to terminate the contracts. Now that was the ground that we were relying on at the time, and I'm now going to go through the parts of the pleading that explain exactly what is in issue in relation to that ground for termination. I've already picked up on 35.2b of the particulars of the claim. I'll just go back to it briefly so that Your Excellency has it in mind. That's it. Sorry, excuse me. That is at page 15 of the bundle. And I've drawn Your Excellency's attention over on page 16 to what the claimant alleges at 35.2b is not that nothing was due, but they had been overcharged of 166,000 on an invoice value of 1.3 million. It didn't at any stage pay the balance, it paid nothing. The defence and counterclaim draws attention to that. First, sorry, my computer's a little slow. It picks up on that first at page 44 of the bundle. This is in relation to the claimant's response to us. Sorry, forgive me. This is our notice to the claimant, and at 53.4, it asserts that we were asking for payment of 1.3 million reals. At 54, we now focus on the claimant's response to that notice on the 27th of September 2023. And at 54.1, what that asserted was that there had been an overcharge of 166,000. And that forms the basis of our counterclaims. And in the reply, where the claimant responds to that, that starts at page 56. I ask Your Excellency to turn down to paragraph 53, page 71. This is the critical plea on which this ground of termination depends. So 53.3, it is admitted in respect of paragraph 53.1 that BLS demanded the sum of 1.3 million. It is denied that the sums of the claimed have, it is denied that the sums claimed had fallen due and or were owing. Paragraph 35.1 and 35.2 of the particular claim are repeated. So it repeats exactly the same paragraph to which I've taken Your Excellency. It is not an allegation of nothing was due. It is an allegation of there was an overcharge of 166,000 reals. The only other relevant plea in relation to the sums that were due at the time is an allegation of suspension. I need to track through that. That starts in the particulars of claim, and one goes down to paragraph 39, which is at page 16 of the bundle. At 39 is on the face of it setting out why we were acting, why our termination was wrongful, even if we were acting in accordance with good faith and the abuse of rights requirements. BS had no entitlement to terminate immediately because, in 39.1, by Article 247 of the UAE Civil Code, the claimants were entitled to suspend the making of payments due to BLS's breaches of the non-compete clause. That is on the face of it the only reference to suspension in the particulars of the claim. The defence and counterclaim picks up on that paragraph 61, which is on page 47 of the bundle. And at 61.2, we say Access or the claimants never exercised any right to suspend the performance of the new Spanish contracts or the Cyprus contracts. On the contrary, they're denied any obligation to perform. So at no stage were we told we are suspending our obligations to pay under this contract. And the reply to that is 62 of the reply, which is on page 73. 62.1, the claimant says this: paragraph 61.1 and 61.2 are denied for the reasons given at paragraph 38 and 39 of the particulars claim, and paragraphs 29, 53, and 54 above. The ALS is not entitled to an order terminating the contracts. The claimants were not required to suspend the performance of the contracts in question. Now, I draw that to Your Excellency's attention, because what that is saying is, as a matter of law, it was unnecessary for the claimants to suspend. So it raises no factual dispute about, they're not suggesting we did in fact suspend. They're simply saying, as a matter of law, it wasn't necessary for that. We weren't required to suspend. That is an issue that can be comfortably determined as a question of law. So in my submission, looking at the preliminary issues that we're suggesting, I'll go now at this stage to the draft order at page 100 of the bundle. The focus of my learned friend's attack is on the first of those, which is paragraph 1A of the proposed draft order, whether the defendant validly terminated each of the subcontracts without the need for a court order because sums are outstanding from the claimant. The key factual dispute in relation to that is in relation to whether any sums were due under these contracts as at the 1st of October 2023. Much of that is common ground on the pleadings. It is not open to the claimant to turn up at trial and say nothing was due in fact, because that is not their pleading. What they can argue is whether it makes a difference legally that there was some amount of overcharging, whether that renders the invoices deficient, and whether that leads to the conclusion that the right of termination completely falls away. But those in my submission are confined points of fact that deal with the contemporaneous documents as to what was outstanding, what was invoiced, and whether or not the right to terminate existed. What I do accept is that the court would potentially have to deal with the abuse of rights and the good faith arguments, but those would be decided on a completely different footing. The way in which the claimant's particulars of claims are set out is that we exercised without any right to terminate, and regardless of whether or not we had such a right. In that context, it is obvious why it would be abusive and in breach of the good faith requirements for us to try and terminate. If it were established that there was a significant sum due, those arguments are to be determined against a decided fact of there being a substantial breach by the claimant, which was the very one on which we relied on. So I don't accept my learned friend's points that either it involves a very significant factual dispute, simply that factual dispute does not arise on the pleadings, or that the judge couldn't sensibly deal with the preliminary issue as framed, even with the points about the good faith and abusive process. Issue 2 deals with what the effect of that termination is in relation to the non-compete allegation. And again, I accept that the effect of that might be that some part of the non-compete obligation and some part of that claim goes forward to a damages claim. In fact, the result of all of these preliminary issues is that there would have to be some form of quantification of our financial claims and the claimant's financial claims. But why they're nonetheless appropriate is that those financial claims will have become refined, established, and the basis on which they're to be calculated would have become clear. That is the key problem that we're addressing because of the way in which the claimant has pleaded its case, or not pleaded its case, and the directions that it's proposing that we go on to what could be a 9-day trial with 12 witnesses, an exchange of documentation and expert evidence on an unformulated case that creates all sorts of case management difficulties. May I then just look at how these preliminary issues would be given effect in the order? So I'm looking at the draft order. Paragraph 1 sets out what the preliminary issues would be, and I've gone through 1 in some detail. 2 and 3 are points of law that result from those and can be conveniently dealt with without any expert or factual evidence. What we're proposing is there would be production of documents across all issues. That's paragraphs 3 down to 9. The reason for that is, in their case management proposals, the parties have given indications of what they say the cost of that is going to be, and it is relatively modest. So in the claimant's version, which is at page 105, at question 4, the claimant suggests 40,000 dirham in respect of the whole cost of disclosure. I'm sorry, this is defendant. The claimant's one is at page 112 and suggests much the same. So the reason we're proposing disclosure is, 1, it is not an enormous cost and it can be dealt with all at once. We then suggest, going back to the draft order at page 102, that witness statements, but the witness statements would be limited to the preliminary issues. In other words, it would encompass the question of the sums that were due, the communications that we're passing around that are relevant to that issue, the parties may choose to put in whatever factual background they think is relevant to the non-compete allegation. But these are not witness statements that deal with all issues across the entire case. So there's no need, for example, to deal with all of the other termination grounds. And that would be dealt with if it arises at a subsequent trial. And there would be no need for the expert reports that are dealt with from paragraph 14 down to 18. So the duplication, if it exists in my submission, is there would be some further witness statements necessary for the quantum trial, or for any issues that are undetermined by the preliminary issues, but they would deal with separate, discrete issues and don't overlap what is already covered by the preliminary issues. And there would be a second PTR. But that in my submission is almost inevitable, not because of what we're asking the court to do, but because of the way in which the claimant has presented its case and where we are now. Judge, in light of that, I'll make some brief responses in relation to none of my learned friend's case. In the claimant skeleton argument, he set out at paragraph 23 why these issues are unsuitable for preliminary issue. I dealt with most of those. May I just pick up on a couple of them? 23.1 suggests that a trial of all issues isn't going to be much longer than one of the preliminary issues. I hope for the reasons that I've submitted, I've explained the defendant doesn't agree with that. It doesn't compare like with like. The issues that would be dealt with on a preliminary issue, in my submission, could be comfortably dealt with in 2 to 3 days. The difference between us is the extent to which the court has to go through the allegations of the non-compete and the abuse of rights requirements, and to what extent those are necessary to determine the question of whether we're entitled to terminate because of an outstanding debt. At 23.4, my learned friend relies on the pre-trial costs, and again, I hope I've explained why I disagree with that submission. Disclosure we'll be doing at one phase and is at a confined cost. The parties agree on what those costs are going to be, and that there's no overlap or duplication by that exercise. Witness statements, I agree that they would come in 2 phases, but there is no duplication. On the proposals that we're suggesting, the first set of witness statements are directed only to preliminary issues. Any further witness statements would deal with different territory. For the same reason, I don't agree with my learned friend that all of our witnesses would be called. The only relevant witnesses are likely to be those that are dealing with the question of payment and termination. So what was sent, what invoices were sent, what communications were sent, and as to the accounting that led to those invoices being sent. At paragraph 24, my learned friend suggests other matters that are of a factual nature that would need to be determined. In my submission, the list that he set out aren't in any way heavily contested facts or contestable facts. They are largely documentary. So what sums were due and payable, what sums have been paid. 3 and 4 are the only ones that are factual. And at paragraph 25, my learned friend submits that these would not be dispositive. And it depends what he means by that. If he means that the case will have to go on in some form, in that I agree with him. But that doesn't preclude a preliminary issue if it saves in case management terms and gets to the real crux of the dispute between the parties. But what my proposal would do in my submission is mean that there would be a subsequent trial that would probably deal with only quantum. If there are elements of the preliminary issue that the judge would direct for a further occasion, so for example, the good faith and abuse of rights, then the judge would be able to determine that part of that should be determined on a future date. But that doesn't preclude the determination of the preliminary issues. Judge, Your Excellency, those are my submissions, unless I can help you in any particular point.
Thank you. Mr. Friedman, thank you. I suggest that it should be in one trial and not to have 2 trials if this issue was resolved in the trial, then the judge will decide whether there should be a calculation based on quantum or not. But I don't see why there should be two trials to move forward. And in relation to the experts, it is the parties to apply for permission from the courts to rely on experts, yeah? So I suggest that the dates in the case management order to be revised and provided as of one trial, which should not take more than 9 months from the date of the CMC. Yeah?
I'm
do
grateful.
we need? Sorry. We need to fix a timescale for that, and we suggested 9 with the idea that if that reduces, so if it turns out we don't need to call all of our 12 witnesses, then we would give notice to court and reduce. But we would prefer to have a longer period that then gets reduced rather than trying to fix days when the judge may not have the time available in his busy list.
If it's reduced later on, then it's fine, but let's set the date from now. So it depends then later on. It can change, okay, if something comes up.
We were going to suggest that the parties, one option could be that the parties over the following week, we do have some concerns about the number of witnesses that they say they're going to call, and whether that's in reality going to happen. So what we might suggest is that, say, over the following week, we can liaise between the parties. We obviously want a sensible time estimate as well. We could liaise and then see if we can agree a number, having sort of just tried to refine that a bit out between the parties in correspondence. And then if we don't agree it, and I hope everyone will be sensible, if we don't, then we could sort of just write back to you, Judge, very briefly for you to rule on that.
Okay. Anything else?
In terms of the date, I mean, I don't know whether this really is maintained as between Mr. Orham and me. There was just a difference in the date in the order, where our proposal was for a trial start on the 9th of June. Now, I should say, obviously, that is not, I think, just looking at the dates, that's not quite 9 months. So that, well, I mean, it's sort of 9 months and a bit, I think, if my maths is right. So really just 2 points on that, which is firstly whether that would be whether Your Excellency is happy with that, and then secondly, there was, as I say, it's only a week's difference between Mr. Orham and me. We'd suggested that it would be ready and we could start on the 9th of June. He'd said 16th. Just whether Your Excellency has a view on that.
9-month period, I think it's before the 9th of June.
Yes. So a 9-month period, I imagine, would be sort of within
May.
27th of May.
Yeah.
I mean, I was just given that, I mean, we're actually talking about 2 weeks. So our proposal had been that it starts of 9 months and 2 weeks from today. Well, Freddie's proposal was 9 months and 3 weeks from today. Obviously, I'm sure with a timetable that's two weeks shorter, of course, we could come up with sensible directions. But given that we liaise on those dates, I'm in the court's hands really on that. But it was just to raise that point.
Yeah, you can liaise on those dates because, first of all, the expert report part should be by permission of the court, so there should be an application to be filed during that period or previous to that period. And then the dates, if the witnesses will be reduced, then I think the dates will be reduced as well.
Yes. Well, perhaps we can liaise with the registry to see if there's an appropriate window, and try to work it out in that way.
A window for what?
For the trial.
Right. Okay, anyways, but it should be within this time period.
Within 9
The
months.
registry will inform you of the availability during that period as well.
The other point I did just want to raise with Your Excellency is that in relation to the expert evidence, I think it was agreed, but obviously Mr. Ryan will correct me if I'm wrong, but I think it was agreed between the parties that on the basis that the trial would take place as one trial, there should be the expert evidence on quantum. And so given that agreement between the parties had agreed directions for that expert report on the premise that there was going to be one trial. So given that we are here today and that Mr. Oram and I are agreed that there will need to be an expert on quantum, it was just in my submission, rather than take up further time for the courts in relation to an application for permission further down the track, I would ask that the court could consider just giving that permission now to save us coming back.
I think this should be by way of an application as mentioned in the rules.
I'm grateful we can put that in the order. The final point I think from us, the final point now, which I do just want to raise quickly, which is that on our side, the costs of this case management conference have been very substantially increased by the raising of the preliminary issue. Now, I accept, of course, that the costs in relation to case management information sheets and draft directions generally needed to be incurred in any way and would generally be in the case. But for example, I've been working on an hourly rate for this case management conference. As you can see, my skeleton dealt only with the preliminary issue application, where we have been successful. And so I would say that the cost of dealing with the preliminary issues point raised by my learned friend should be my client's costs, because additional costs have been incurred, and we do say that that was obviously unnecessary, and we've succeeded on that.
Any response from the defendant?
Yes, Judge, I pose that application. It's quite proper for an application that's to do with case management, the defendant to take a point about case management. The reason we made it, for the reasons I've set out, is that it starts with a deficiency in the claimant's own pleading. On no basis is that a pleading for a $9 million claim. And we were concerned that if this case goes to trial in one hit, there is going to be a case management problem with addressing that case on quantum. So it was quite proper to raise that at this CMC. The fact that it's been determined in one way doesn't in any way mean that the point was a bad one to be taken. And in those circumstances, it should be treated as a case management cost and cost in the case.
I agree, it's cost in the case. Anything else?
No, thank you, Your Excellency.
That's all from us. Thank you very much, Your Excellency.
Thank you.